Honored to host you this afternoon. Karibuni. I would like you to feel right at home. You are welcome for this very important discussion this afternoon. We are very privileged to have a very distinguished and unique panel of experts that will be introduced a little later by our esteemed moderator. But on behalf of the East Africa Law Society, I would like to extend our very warm welcome to you all and a very warm appreciation for your continuous support and attendance to our webinar sessions every week. As we move towards the close of the month, I would like to inform members that we have our in-house council convention that is happening on the 5th and 6th of September 2024 and in Kenya at Watamu. Watamu is in Kilifi for those of us who are not from Kenya. So if you're in-house counsel or you're interested in in-house counsel practice, please purpose to attend. It's going to be the largest convening of in-house counsel in Eastern Central Africa. So you do not want to miss that convening. And also, as we gear up towards September, I would like to bring to your attention that we have a FIDIC Construction Law Conference happening in Kigali, Rwanda, from the 25th to the 27th of September 2024. And we look forward to hosting you at the Grand Marriott Hotel in Kigali for these discussions on construction law. Now, back to our webinar session this afternoon. We are extremely privileged to have this discussion on cross-border tax litigation, and we'll be delving into the key trends, development, and opportunities. And to take us through this webinar is our esteemed moderator, Ms. Rachel Kembabazi, who is a principal associate with Signum Advocates. Rachel is a bright, passionate and ambitious Ugandan lawyer with a vast wealth and a proven track record of providing indispensable advice to clients and delivering positive outcomes for them. She specializes in banking and finance and has quite a considerable experience in bank regulatory matters as well as deal structuring, corporate advisory, and tax advisory. She has over 7 years of experience in providing legal services. She's a member of the East Africa Law Society and Uganda Law Society, and we're privileged to have her as a member of our banking and finance cluster at the Uganda Law Society and a member of the Young Lawyers Committee of the East Africa Law Society, where she volunteers. Rachel has also been endorsed by the legal fraternity in Uganda and Africa at large to have recently been nominated for the Rising Star and Newcomers Awards by Legal Africa Awards 2019, 2020, and 2021, respectfully. She has also been nominated by the Uganda Law Society as a Rising Star in August 2021, and hopefully in 2024, she will get a nomination and take it right home. So, ladies and gentlemen, let's welcome Rachel. Rachel, we are all yours for the next 2 hours. You can come give us guidance, and we are really honored to have you once again this afternoon.
Thank you so much, Gabriel, for the kind introduction, and I'm happy to be here this afternoon with East Africa, with the lawyers in East Africa, and happy to moderate this session. I don't even think I should say more words to this, knowing that we have quite a panel that we must give all the time to listen to them and to learn from them. I'm also here to learn, and part of my practice as well is tax litigation. So I'm excited for this session. I'm excited for the experiences that are happening across the board all over East Africa. We've recently had, I think, a bit of changes ourselves in Uganda. We have a new committee at the Tax Appeals Tribunal. That's with a change in the chairpersons, and we are happy to welcome a new chairperson to the committee, Ms. Crystal Kavajwara, that has recently started her term of office. And I must say that also for Uganda, we have a bit of traction with the Tax Appeals Tribunal. It's one of the tribunals that we usually look forward to appearing before because, unlike any other litigation across the country, tax is quite interesting. It comes and it's faster, and there are results for clients. But yes, other than the litigation side, there's also a bit of traction with the Uganda Revenue Authority. That's in terms of dispute resolution. And we must say that we are extremely grateful to the government and what's happening in Uganda. So we also have an active ADR department at the Uganda Revenue Authority while they try to resolve disputes, before you go into the fully blown litigation. And that's good good strides that have been made. So it's at this juncture that you'll allow me to welcome our panelists, and I'm happy to say that I'll be starting home. That's with the first panelist this afternoon, Mr. Rukundo Solomon, that is with us, and thankfully happens to come from the government of Uganda as well. Mr. Rukundo is a specialist with the Ministry of Finance, Planning and Economic Development. So please welcome with me Solomon as I continue to introduce him. And briefly, Solomon has 10 years experience in the field of taxation. He's currently a tax specialist, as I said, in the tax policy department of the Ministry of Finance, Planning and Economic Development in Uganda. Before this, he was a manager taxation at the Grant Thornton audit firm for 2 years. He has also previously held the position of supervisor in the Rulings and Interpretations Unit of the Uganda Revenue Authority, where he has worked for 7 years. He has published papers, journal articles, and book chapters relating to tax matters in the East African Journal of Peace and Human Rights, that's the Journal of African Law, and the Africa Tax Research Network, and the International Center for Tax and Development in the URA Research Bulletin. He holds a law degree from the University of Dar es Salaam, and a postgraduate diploma in legal practice at the Law Development Center in Kampala. Please allow me to welcome Solomon this afternoon. Solomon, you're most welcome, and the topic that Solomon will be delivering this afternoon is specifically on principles of cross-border tax litigation, its causes, and a situational analysis for cross-border tax disputes in East Africa. Mr. Rukundo, you're welcome, and over to you.
Thank you very much, Rachel. I will try and share.
Solomon, I think you're a bit low. I don't know if I'm the only one struggling to hear you, but we can barely hear you.
Am I too low?
You're still far from your earpiece or your mouthpiece.
Even now?
Yeah, this is much better.
Okay. So good afternoon, everyone.
Good afternoon to you, Solomon.
Yes. So I'll be taking you through the principle of cross-border tax litigation and its causes and the situation analysis of the cross-border tax disputes in East Africa. So basically, cross-border litigation is litigation across borders. That is when you're with a lawyer in one firm in one jurisdiction goes to litigate in a different jurisdiction. It's also, you could also consider it cross-border litigation if there is the similar matter being dealt with across borders. So, for example, if perhaps a decision made in one jurisdiction is going to have impact in another, it could also be considered some form of cross-border litigation. So, generally, in cross-border litigation, the preference is for arbitration ordinarily. That is in ordinary commercial disputes. There is much preference for arbitration, as is highlighted in this case. This is a Ugandan case where they highlight the fact that it's very much preferred that a matter be resolved through arbitration when it involves cross-border litigation, because it allows one to bypass the risks of conflicting laws and the likes. So with regards to tax litigation, cross-border tax litigation arises because of the considerable mobility of labor and the increase in cross-border business. It leads to disputes that can come up across jurisdictions. Various kinds of disputes can arise, where usually it's one country claiming to tax that particular that particular income earned. And another challenge is when jurisdictions treat cross-border transactions differently. That is, the transaction is happening across two different jurisdictions, and one jurisdiction treats it one way, another one treats it another way. So, for example, if there is a transaction happening and one is treating it as debt, while another one is treating it as equity between two related companies. Then also international tax issues can arise where you have conflicts like source versus source, residence versus residence, and source versus residence. So source versus source is when two jurisdictions are claiming that a particular type of income or particular income is sourced from both jurisdictions. So each of the jurisdictions, according to their source rules, they are saying that the income was earned from those jurisdictions and is therefore taxable. Or residence versus residence is when two jurisdictions are claiming that the particular taxpayer is a resident of both jurisdictions, and under normal international tax rules would be subject uh, to tax on income earned worldwide in each of those jurisdictions. Then you have the source versus residence, where you have one is a resident of a jurisdiction taxed on income sourced globally, and yet also on the basis of source, because they are sourcing that income from a different jurisdiction, that income is being taxed in that jurisdiction. So that's how different conflicts can arise that can result in cross-border tax litigation. So within East Africa, there is a bit of a legal framework for cross-border litigation, which can be applied to tax. The East African Community Treaty, Article 76, provides for free movement of labor and of services. Article 126 of the East African Treaty also provides that for promotion of the objectives of the East African community, the partner states are to take steps to harmonize their legal training and certification. However, this is currently not being done. Also, standardization of judgments across the East African community, but this is also not really being done. Not much progress has been made. Article 126 of the East African Community also provides for a common syllabus for training of lawyers and a common standard for examinations for qualifications and admission to the bar, but that's also not being fully implemented at the moment. The East African Community Common Market Protocol, Article 2, provides for the free movement of labor and free movement of services. Article 5 provides for that partner states shall agree to remove any restrictions on movement of labor and harmonize labor policies. And Article 5 also provides for cooperation in harmonizing and mutual recognition of academic and professional qualifications. So this would facilitate litigation if a lawyer were to move across, that is, if they were being fully implemented. However, as we shall see, that's not yet being done. Article 10 of the East African Community Common Market Protocol provides that the partner states shall guarantee free movement of workers who are citizens. Article 11 also provides that for ensuring the free movement of labor, the partner states shall undertake to mutually recognize the academic and professional qualifications, again, similar to what has been said, and also guarantees the freedom of movement of services, Article 16 of the Common Market Protocol. So the aim was to liberalize legal services so that they can be accessed by all across. And indeed, a bill was introduced in the East African Legislative Assembly in 2014. However, to date, it has not yet been actualized. So it remains pending. Also, regulations for the mutual recognition of academic and professional qualifications um, were proposed, but have also not yet been implemented as yet. However, there is a comment in one interesting article, journal article I found by Dr. P. Habimana of Rwanda, that there is evidence-based optimism that the practice of law in the East African community will one day cross borders. So with that, we can see that there is generally limited room for direct litigation, an opportunity for one practitioner in one jurisdiction to go and litigate a matter in a different jurisdiction. However, the disputes that are cross-border do arise that could have been facilitated by litigation if such litigation were taking place. And some of the disputes that have come up leading to cross-border litigation in some form, at least. One is disputes relating to the East African Community Treaty. So one interesting case, given that it had tax dimensions, is the British American Tobacco versus the Attorney General of Uganda, was in the East African Court of Justice, where British American Tobacco argued that the fact that Uganda was using the excise duty law to discriminate against cigarettes produced in Kenya. So the Ugandan government, the excise duty law provided for higher rates of excise duty when the cigarettes are imported. And Uganda was treating the cigarettes imported from Kenya as cigarettes which are being imported. And so the dispute was taken to the East African Court of Justice, and the court held that Uganda had violated its obligations to allow for the free movement of goods in East Africa by treating the cigarettes from Kenya as imported and therefore subject to the higher rate of duty. So cross-border disputes, tax disputes, can also arise just as a result of transactions happening across the border. Now, in this particular illustration I'm giving, there wasn't per se a cross-border dispute, but it did arise from a cross-border transaction, and it was giving rise to a sort of absurdity in the treatment that was being adopted. So the company in Uganda, Roche Transport, was contracted to transport goods into Uganda by a local company here in Uganda, and it subcontracted the work to a Kenyan-based transport company called Ultra Eureka Farm Limited. That's UEFL. So UEFL transported the goods into Uganda, and then the Uganda Revenue Authority assessed Roche, that's the local transport company, for not withholding on the payments to UEFL. Now, globally, the norm is that such transactions wouldn't be subjected to that withholding tax, or if subjected, would be subjected to a much reduced rate. And the reason being that this UEFL would ordinarily be subject to tax in Kenya as well. And so the transaction is in any case looked at as happening in Kenya because it's commencing in Kenya, where the transportation is beginning. And so subjecting it to the withholding tax would have led to scenarios of double taxation. So the court found there was ambiguity in the law that URA was trying to rely on, and ultimately it ruled that the transactions would be considered as exempt and not subject to the withholding tax. To the withholding tax. Yeah. Yeah. So another source of possible conflict is scenarios where you have multinationals and there is a different treatment of the transaction. So this one, I know there's one practical example when I was working in an audit firm. When I was in the audit firm, I had a scenario where the Ugandan company had a subsidiary in Kenya and had loaned money to the subsidiary in Kenya. And now the subsidiary in Kenya had opted to convert that debt into equity. So the challenge arose because the challenge arose because the entity in the KRA in Kenya was disputing whether or not the wanted to restructure the conversion, and also disputing was considering different tax treatments of it. Now that was going to be a big challenge because you would then have a situation of somewhat an absurdity, because you would have the transaction treated one way in Kenya, and yet in Uganda it could be treated a different way, and that would lead to a considerable challenge, and would probably need to be resolved. And we also had it can also arise from international tax issues, as I had discussed earlier. As I had discussed earlier, but just sorry, could you just give me a second? Yeah, yeah. So the international tax issues can arise all related to transfer pricing. So in the case of East African breweries, it's a good example of how the challenge can arise. East African Breweries International, it's a group, member of a wider group of companies that are operating all over in East Africa. But the company member, it didn't have any physical presence in Uganda, but was exporting goods, and the revenue authority was treating it as a resident in Uganda for that reason. And there were, when one looks at the details, there were transfer pricing considerations that could come up, and the revenue authority may not have been entirely wrong to do so. So it was recharacterized, and they were considered as residents of Uganda. And of course, there were also residents in the other jurisdiction, and that was going to cause a conflict and would give rise to that kind of dispute. And then there is the failure to ratify the East African Community Double Taxation Agreement, and this has been a challenge. This has been a challenge because without it, there is a constant risk of double taxation. And it's given that within the East African community, there is more and more business increasing. You have more and more cross-border transactions happening. The risks that I had mentioned earlier of source versus source, of residence versus residence, and residence versus source are really heightened. And so there is a need to pass the double taxation agreement in order to resolve this and limit that risk. So currently, when such situations arise, I encountered such cross-border disputes while primarily in my brief foray in the audit firm for 2 years. I left about a month ago to join the tax policy department. And in that period, I had noted one of the tools we could use was relying on the global network of firms. So Grant Thornton, the firm I was in, was an international firm. And so we could easily rely on Grant Thornton Tanzania and Grant Thornton Kenya while dealing with these challenges. Then also collaborating with other firms across the border. At one point I had an opportunity to do this because as Rachel had mentioned, I did my undergraduate in the University of Dar es Salaam, And so I have a network in Tanzania of lawyers I studied with, and through the alumni network, sometimes when I've needed to deal with cross-border issues, I've been able to rely on that. And then also familiarizing oneself with the tax laws of other jurisdictions. In particular, because of the frequency of transactions across borders within East Africa, I actually had to read the East Africa, the Kenyan income tax law, the Income Tax Act of Kenya. I had to read it quite a bit, both even before, while I was in the Revenue Authority, I had to read it for research purposes. But then during practice, I had to read it in order to give guidance. Sometimes we did have clients who would require even some guidance on how the transaction might be treated in another jurisdiction. And we would have to sometimes give them at least some preliminary guidance or possible treatment of some of those transactions. So in conclusion, the opportunities that exist for cross-border litigation, we can have temporary provision of legal services across the borders. That is still difficult, as we've seen. The legal framework is not yet well laid out. Chances of acting as expert witnesses on foreign law, where that comes up as an issue, and work in arbitration, since that's the main mechanism of dealing with the cross-border disputes. So I know my fellow panelists will have their own topics to discuss, but if possible, I would love to hear from them with regards to some of the causes they might have encountered of cross-border disputes. If there are any aside from the ones I have highlighted that they might have encountered, if possible, they could share. Yes.
Thank you very much, Solomon. I think you have covered comprehensively. And the only other issues I'd say is that increasingly we are seeing audits and some of the audits that are being done in East Africa to also go quite into a lot of depth on documentation issues. So that is something that I can touch on briefly on my presentation. Thank you very much, Solomon.
Patrick, anything?
I think you've covered it very well. Maybe I could give some few comments at the very end once I've done my presentation.
Okay, perfect. So then that's it for my presentation. I welcome any questions that you may have.
Thank you very much, Solomon. Thank you for that detailed presentation, even with the short time that you had to deliver it. We are grateful for it. And I think I'll take any questions that you might have for Solomon. Please feel free to either type them in the chat or to raise your hand so that we can quickly take the questions before we release Solomon of the platform now. Are there any questions? But also feel free to ask these questions even once Solomon has stepped away and someone else is speaking, and we can always pick them up and respond to them. Please feel free to drop your questions in the chat or to raise your hand. Okay, so thank you very much, Solomon. I think we do not have any questions at the moment or in the meantime. Thank you so much for the presentation delivered. Maybe just one question is on whether you could share the slides after this, and indeed the these are usually shared with the participants, and they will definitely be shared after this session. So thank you so much again. Yes, so dear participants, allow me go to the next phase of our session today, or next chapter of our session today, and we'll now take it back to practice, or to the legal day-to-day practice with Daniel Ngomi, who's present with us. And Daniel will be speaking to the role of alternative dispute resolution in resolving cross-border tax disputes. But let me start with introducing Daniel and who he is. Daniel is currently the managing partner and head of tax at ALN Kenya, that's Anjarala and Kana. He heads the firm's tax department. He specializes in regional and international taxation law. He has extensive experience in tax disputes and tax transactional matters. Daniel provides tax advice on matters affecting clients across various industries, including the financial sector, power, energy and infrastructure, oil and gas, FMCG, amongst others. He's advised on a variety of matters, from debt and equity transactions to mergers and acquisitions. And besides that, Daniel chairs the Law Society of Kenya's Tax Committee and a task force on the development of national electric mobility policy, strategy, legislations, and regulations. That's the e-mobility task force, and was recently re-elected as a member of the American Chamber of Commerce, Kenya Board of Directors. He's a regular speaker at the local and international conferences. He's ranked by Chambers Global as a leading tax practitioner and under the private wealth law. Daniel is also qualified as a CPA and holds a Bachelor of Laws degree from the University of Nairobi and a postgraduate certificate in tax law and a Master of Laws degree from the University of London. That's UCL and Queen Mary. Please welcome with me Daniel as he delves into the role of alternative dispute resolution, or ADR, in resolving cross-border tax disputes. Daniel, you're welcome. Karibuni, and we're excited to hear from you. Thank you.
Thank you so much, Rachel. Can you hear me okay?
Yes, we can hear you perfectly.
Okay. Thank you very much. Good afternoon to you all. Also very good to have had the privilege of listening to Solomon. And I look forward to also listening to Patrick Chege, the other panelist who is coming after me. Mine will not be very detailed. I'll be quite brief in terms of this discussion, because we've had quite a good background on the causes of cross-border disputes. I think I will just very quickly just add to the points that had been made by Solomon. Really, the main sources of disputes that we have seen on cross-border issues, I can put them into those buckets you see in there. I would say they would fall into double tax treaty disputes, which we have seen quite a lot of, transfer pricing disputes. Transfer pricing, very briefly put,
Daniel, I think we've lost you a bit. You seem frozen.
Can you hear me?
Yes, we can hear you now.
I've switched off my camera just for better bandwidth. I hope you can hear me clearly.
Thank you.
Okay. So I was saying that in terms of the disputes that we often see, transfer pricing is another source. I know it had been touched on. And another issue is really this thing we call permanent establishments. It had also been touched on. Moving on, really, and I don't want to go into too much detail around these sort of issues. I think one of the key things that we have seen, and Rachel, you can confirm whether you're seeing slide number 7, which talks about key audit trends in Kenya.
Yes, perfectly.
Okay. So effectively, part of the reason why we have seen challenges in being able to arbitrate and settle disputes out of court, just to sort of highlight, what tends to happen is that after you have received the dispute or the dispute has commenced, there is a process where you will try to speak to the revenue authority even before the dispute has crystallized in full. Before the objection is confirmed,
Okay,
there is a
Daniel. Daniel, we lost a bit. We lost you a bit, so we lost part of what you were saying. I don't know
Oh,
if you
no.
could just.
I think my connection might not be that good.
Sorry.
Let me try and change connections. Can everybody else hear me or?
Yes, we can hear you now. We just lost you a bit, but we can hear you now.
Okay. So I was saying that there is occasionally the unwillingness to drop issues at the objection stage. And what we have seen is that being able to spend some time, it's almost like a quasi-arbitration section where you seek to liaise with the Revenue Authority to see whether some of the audit issues can be dropped. We have also seen a significant enhancement in the capacity of the revenue authorities in Kenya, particularly with foreign tax expertise. So what we are seeing as a consequence is that there is an increase in cross-border tax disputes, really driven by capacity and e-learning tools and the guidance they have received from foreign experts. And obviously, one other real challenge in Kenya is that there are increased complexities in tax law. So we are now seeing enhanced documentation requirements. We are seeing enhanced requirements for TP regulations and enhanced definitions in our law to deal with what is control and what preferential tax regimes are. Obviously, in Kenya, we are seeing greater aggressiveness in terms of the way transfer pricing issues are being dealt with. So the days of being able to reach very quick settlement with the Revenue Authority on issues has become more and more challenging. And as a consequence, what we're seeing is that the government as a whole, the Revenue Authority in particular, has been pushing more and more for matters to go into the alternative dispute resolution mechanism. Part of the reason for this is because there is a suggestion that there is a lot of revenue that is tied up in tax disputes. In Kenya, the requirement for you to deposit any money on account of an appeal from the Tax Appeals Tribunal, first of all, an appeal to the Tax Appeals Tribunal only requires a deposit of 20,000 shillings. And an appeal from the Tax Appeals Tribunal to the High Court, there is no requirement for a deposit for that appeal, save for the fact that usually courts can require some form of amount to be paid on account of stay, pending hearing and determination. And consequently, a lot of the matters have been able to proceed quite quickly on appeal, therefore meaning that from revenue's perspective, a lot of money is tied up in tax disputes. As a consequence, we are seeing a greater push to alternative dispute resolution because it is seen, at least from the revenues perspective, as a way of unlocking the revenues that have been tied up in disputes with the Revenue Authority. So against that background, I just want to go to mechanisms of resolution, which is really the purpose for which I was requested to speak. As I mentioned, and this is really to highlight the process, in Kenya, when you receive a tax decision by the Revenue Authority, you're required to file an objection with the commissioner within 30 days of being notified of the decision. The commissioner has 60 days to make an objection decision. If the commissioner fails to respond within that period, the objection is automatically deemed allowed. However, usually the commissioner responds within that 60-day period. The taxpayer can request an extension of time to file an objection if they are unable to do so for reasonable cause. Usually it's absence or illness, and the commissioner has the discretion to grant this extension. Typically, I have not seen many people being successful in seeking outside of that period of time. There is an appeal from there to the Tax Appeals Tribunal if you're dissatisfied with the decision of the Revenue Authority. You can appeal to what we call the Tax Appeals Tribunal, the TAT. And the proceedings before the TAT tend to be judicial in nature. The Civil Procedure Act does not apply, but there is quite a lot of procedure that needs to be followed. If you lose at the TAT and you're dissatisfied with the tribunal's decision, either party can appeal to the High Court within 30 days of being notified. And typically, the appeals to the High Court revolve on questions of law. What that effectively means is that the taxpayer is generally restricted on introduction of new grounds unless they had been covered in the initial documents that were filed, or unless you can seek the leave of the court to do so, and the Revenue Authority does not object. There is a further appeal to the Court of Appeal in Kenya, and that allows you to then file an appeal to the High Court. Again, 30-day period to do so. And based on our law, you can only appeal on questions of law. Exceptionally, it is possible to appeal to the Supreme Court. And I say exceptionally because effectively you can only go to the Supreme Court if there is a matter of public interest that allows you to go to the Court of Appeal, to the Supreme Court. This process, I know, mirrors quite substantially both Tanzania and Uganda. Although in the case of both Uganda and Tanzania, I know that there is a requirement for paying an amount prior to appeal, as I have highlighted. In the case of Kenya, the objection decision is an internal process within the Kenya Revenue Authority. The appeal from the appeal to the Tax Appeals Tribunal requires only a deposit of 20,000 Kenya shillings. The appeal to the High Court, presently, there is a change in law that was effected, which allows for, as long as you have filed an appeal, there is no requirement for you to pay anything. But increasingly, there is now, in the absence of such a provision, what used to happen previously was that the High Court would require some form of deposit pending hearing for you to secure stay. And that deposit would typically be negotiated between the Revenue Authority and the taxpayer. And I think the process continues to the Court of Appeal. And as I said, there's an exceptional appeal to the Supreme Court to the extent that you're able to demonstrate that there is a public interest element. So therefore, this whole process can mean that a dispute that begins from the tax decision all the way to the Court of Appeal and potentially to the Supreme Court can take very long. There was one case that I was involving the bottlers in Kenya. I think Patrick Chege at the time was in the Kenya Revenue Authority at the time when that matter started. And the first appeal was filed in 2009. And the decision by the Court of Appeal was given in 2019. So that was a 10-year period for the process to have gone from start to all the way to the Court of Appeal. And in 2020, there was an appeal to the Supreme Court, which fortunately was concluded quickly. It was concluded by 2021. So you can see it's a 10-year to 12-year journey from the time the matter starts. At least from the revenue's perspective, if you're able to secure stay pending hearing and determination, it means that they have not received any money during that whole period of time. So effectively, it gives room, increasingly in Kenya has given that urgency for matters to go through arbitration or mediation for that matter. So what we are increasingly seeing in Kenya is that settlements out of court or out of this legal process that I have just described have been pushed through the various things that we're seeing there. One method is mediation. We call it mediation because it's not really arbitration in Kenya. Because what tends to happen is that in each of the facets of the appeal, you have what is, in particular, you have what is called the ADR team from the Revenue Authority. The ADR officer has no real power to impose a decision. What the ADR team from the Revenue Authority has is to facilitate an outcome. They effectively operate as facilitators. And what they then do as facilitators is to bring the parties together to try and define the issues in dispute, to see which issues that can be dropped, which fall outside that process, and then you end up reaching some form of outcome. So mediation is quite, while we call it ADR in Kenya, it is less ADR because arbitration usually supposes an independent arbiter who can give a binding decision. Mediation tends to be where you facilitate a concurrence by bringing the parties together. The second thing is a direct negotiation between parties. Again, this we have seen being a good channel. And actually, whenever you look at, if looking at this process that I had indicated, where you start with the tax objection decision, you go to the appeal, you go to the High Court, there are various levels of intervention that parties can intervene directly with the Revenue Authority. So while the matter is still in the first category, which is where you've received the tax decision, during that 60-day period pending the decision from the commissioner, it is not unusual for parties to try and speak directly with the Revenue Authority in order to see whether certain things can be dropped. And that is done through what is called the Independent Review Office of the Revenue Authority. Because this process is still within the Kenya Revenue Authority's remit, it tends to be almost like a negotiation between yourself and the Revenue Authority, or a combination of direct negotiations and mediation in order for that outcome to reach some conclusion. There is, I will touch towards the end where you can use, and it is also an ADR mechanism, almost a type of a mutual agreement procedure. That tends to be where there is a double tax treaty involved. One could argue that under the mechanisms now for transfer pricing, that advanced pricing mechanisms are also ADR. And eventually there are certain tax treaties that where you can call on an actual independent arbitration, but that is a very rare outcome. So mediation, as I have mentioned, is Kenya Revenue Authority has created an internal dispute resolution mechanism. And typically it is allowed at any level of a dispute. It is facilitated, and therefore the distinction that I'm creating between arbitration is where there is an arbiter who can give a binding decision, and mediation, which is a facilitated discussion between the parties for purposes of resolving and settling the dispute between the parties. The key thing in Kenya is that mediation, or this sort of facilitated dispute resolution, can occur at any stage of this dispute. So, as I said, when you look at these levels, it is possible for you to get intervention from the Kenya Revenue Authority's body, which is involved in ADR, for intervention for at any level. You can do it at the IRO stage. IRO is the Independent Review Office before an objection decision has been given. You can do it through the ADR team at the Tax Appeals Tribunal. Even after you have received a decision of the Tax Appeals Tribunal and you have appealed to the High Court, it is possible for you to invoke the process of arbitration at that level. And I have seen it occasionally also engaged when you have gone to the Court of Appeal, where it is possible for you to also engage in that process. The position after you have filed at the Tax Appeals Tribunal, you would need to seek leave of the 120 days for that matter to be settled. And we're now increasingly seeing on exceptional basis that even after the expiry of the 120 days period, that it is possible for you to continue engaging with the taxpayer. Now, when do you engage with KRA's independent review team? Based on KRA's ADR framework, the parties can do so, first of all, in the case where an objection has been raised. You can request for the ADR to be given. The parties of that process would usually be the taxpayer, the commissioner, and the facilitator. It is important for me to highlight that in the case of the facilitator would be, for all intents and purposes, still part of the Revenue Authority. So sometimes, and I will welcome views from both Solomon and from Patrick, there are question marks that usually sometimes arise as to how independent that process is, because the facilitator is part of the Revenue Authority. The good thing is that they don't sit in the same office, and therefore effectively they can bring a fresh pair of eyes to review the decision that had been made by the commissioner. The role of the facilitator is to convene the meeting, to provide administrative guidance. So they chair the meeting, they manage the meeting. Sometimes they have to cool the tempers, because as taxpayers, with their representative being the lawyers in the room and accountants or other agents, sometimes the temperatures can rise. And therefore, their role is to also manage the meeting to make sure that there is no altercation or blows exchanged, but to make sure that the process is then reaches the conclusion from a facilitatory perspective. To the extent that there is a meeting, a settlement that is reached at that level, the KRA's facilitator would usually draw up the first draft of the ADR agreement. It is important for me to highlight that typically they also take minutes, and the minutes are shared with the parties so that there is a record of the matters that were discussed. And finally, they conclude with the signing of an amicable agreement. It is very, very important for me to highlight that this whole process is undertaken on what we call on a without prejudice basis. Therefore, if you fail to reach conclusion during this process, none of the discussions, admissions that were done during ADR can be placed before either the tribunal or the court or wherever level you are at as evidence of an admission. Because what tends to happen is that in the give or take that happens through this process, sometimes a taxpayer would say, in order for you to allow for Kenya Revenue Authority to agree to a settlement, you may be willing to concede on certain aspects or issues. And that concession in the interest of reaching a settlement is in fact, for all intents and purposes, could be construed to be an admission. But because you are doing this on a without prejudice basis, that admission or concession through the ADR process cannot be then taken as an admission for purposes of adducing new evidence to the tax appeals tribunal or the court or the high court, as the case may be, depending on where the process had reached. So this is quite an important thing. Again, I rush to say that the facilitator has no binding power. So the facilitator cannot say that I agree with
Daniel, we've lost you.
purely.
Okay, you're back now. We had lost
When
you.
did you lose me, Rachel?
You were just, the point you just made is what we lost. Not so long ago.
Okay, I will repeat the point. Okay, I will repeat the point. So I was saying that
Daniel, are you there? Okay, I think Daniel just dropped off. Just give it a minute for him to just dial back on. Daniel, can you hear us? I see that you're back.
Can you hear me?
Yes, we can hear you now perfectly.
Very sorry. I think I was disconnected. Apologies for that.
That's all right.
I have put back my slides. Can you see my slides now?
Yes, we
Actually,
can see.
Role of facilitator.
Yes, we know we are seeing CARE's IDRM process. Yes. Is that a slide you intend for us to see?
Yes.
Oh, that's the slide you are on. Yes, perfect. We see it now.
Okay. Okay. So let me carry on. Please let me know if we have any other challenges. But I hope that we'll be able to proceed effectively. So what I was saying is that I was just explaining the role of the facilitator. And from a perspective of the facilitator's role, they cannot give a binding decision on anything. Their role really is to facilitate those discussions. Now, what we have seen, generally speaking, the disputes that are unsuitable for ADR discussions, where it is, even if you go through that ADR process, it is very unlikely that you will be able to reach a reluctance. If, for example, there is a clear provision of the law that stipulates that the outcome of the law would be contrary if it is reached in settlement, we have tended to see an inability to reach settlement where there is a technical interpretation of the law. We have tended to see a challenge in reaching a settlement where public interest would be an issue. We have seen reluctance where, for example, through the courts would promote significant compliance. And we have also seen certain instances where, for example, the Revenue Authority would say that if we agree this with you, it will have a binding outcome on other taxpayers who have similar cases. And finally, you cannot force anyone to engage in ADR. It's completely optional. Now, we have explained, I had explained through this process that usually you would send a notice of intention in prescribed form for you to engage in ADR. That is usually acknowledged by email, and then it will be allocated to a case manager. Case manager will then confirm the suitability of the matter to go through ADR, and then you will be invited for a preliminary ADR meeting. So what I'm showing now on my screen, and I will share these slides, is actually a process flow that has been shared by the Revenue Authority. And they have put this on their website. The net sum of the whole process, the most key things are that there's a decision to be made on whether on the suitability of the ADR. The ADR is facilitated. There is another decision to be made, which is shown in that quadrangle, which effectively says that has there been a concession on ADR. If there is a concession, then the matters are then drafted to reach some form of settlement, and you enter into an ADR agreement. The other alternative is for the matter not to reach conclusion, and the matter is referred back to the TAT or to the court for the decision making to be undertaken. In all cases, the ADR team in the Revenue Authority will keep the documentation for purposes of keeping that file, and that matter is then kept available. Rachel, I trust that you can still hear me.
Yes, we can hear you. I confirm that we can hear you perfectly.
Great. So I wanted to also highlight that it is possible that you underwent a DR at the TAT level, you failed to reach a DR or failed to reach a settlement. The matter then went on appeal to the High Court. When the matter went on the appeal to the High Court, again, you can get a second bite of the cherry. But usually there is a lot of reluctance because you would need to demonstrate to the Revenue Authority and to the parties, really, particularly the ADR team, on the suitability. Are there new issues? Are there new grounds? Is there a different basis that will reach a different outcome from that which had been initiated when you had, for example, gone on a DR at the TAT level before the matter going to the High Court? The other point that I think will be relevant to bear in mind, as I had said at the beginning, is that it is possible to initiate ADR at any level, whether it's at the TAT level or the High Court or the Court of Appeal. But typically, the timelines would be at the TAT level 120 days, and at the High Court, you'll be guided by the calendar of the court. The court usually allows 90 to 120 days for ADR, but it is possible for that timeline to be extended to the extent that there is a basis for you to extend that timeline. So if you were to look at the key advantages of ADR, one of the key advantages, of course, is the fact that it can be quite quick for purposes of reaching that settlement. I have already talked through all these processes, but also typically the downside really is just the fact that the facilitator is also part of the Revenue Authority, and the facilitator has no real power to reach a binding conclusion, but his role is to guide the outcomes through a facilitated process. The real issue, speaking as a practitioner, is that we tend to try as much as possible to take matters through ADR, because ADR can have the slight benefit of having certain issues dropped. So for example, as I had said, typically we see that cases in Kenya would encompass various issues. So in this issue that I had highlighted here, I had indicated that you could find that some of the key challenges you have is that some of them are documentation related, some of them are legal issues which have real issues that need to be debated before the Tax Appeals Tribunal. So one of the ways of going through this ADR process is that you have the real advantage of dropping off the issues that can be capable of being dropped off. So for example, where there is an issue that is technical for interpretation purposes, that proceeds to the Tax Appeals Tribunal or the High Court, as the case may be. And issues of documentation, if, for example, it was to do with reconciliations and the likes, are dropped through ADR. So we try as much as possible to have matters go through ADR, because there is a benefit that could arise where you define better the matters that will go to the High Court or the Tax Appeals Tribunal, as the case may be, and matters of reconciliation are dropped off through the ADR processes. And the final point that I wanted to highlight is that at the end of the day, even after you have signed the ADR agreement must then be taken before the Tax Appeals Tribunal or the High Court for purposes of recording the consent. And the consent can be a consent reached in respect of the entire matter being closed and settled, or a consent could be a partial consent where certain issues that were in dispute before the Tax Appeals Tribunal or the High Court are dropped, and only the matters that remain in dispute are then recorded. So whereas the ADR agreement is an agreement that will be the concurrence and signed by both the Revenue Authority and the taxpayer, in order for that to be reflected in the court process, it is then reduced into a consent that will be filed before the relevant body. So I think that is a summary of this process in Kenya. As I have said, that we see certain advantages, certain disadvantages of going through this process, but increasingly as a matter of cost, because of the possibility of dropping certain issues, we tend to see that everybody will want to take the matter to the Tax Appeals Tribunal, to the ADR process, just to see whether there's an outcome that could be positive. I want to very briefly talk about the mutual agreement procedure. As you had seen at the beginning, I had said that one of the ways that a dispute could arise is where there's a double tax treaty in place. And the mutual agreement procedure is an inbuilt process within the double tax treaties that allows for the two parties to the double tax treaty to mediate. Now, it is very important to bear in mind that the two parties in a double tax treaty are actually the competent authorities themselves, basically the two revenue authorities. And therefore, the mutual agreement procedure, while it usually is invoked where there is a dispute pertaining to a taxpayer, in real sense, the mutual agreement procedure requires the two authorities to sit together and try and amicably resolve the interpretation of the treaty on an issue. The obligation is to use their best endeavors, and because it is a best endeavors obligation, there is no outcome that forces an outcome, and therefore it tends to be, for all intents and purposes, again, one where the two authorities will try and reach a compromise, and this will usually range from an agreement on valuation or an ability to settle when parties agree to reach a compromise. The typical areas for possible MAP tend to be the question to do with Article 25 of the double tax treaties. Usually it's a question as to whether a PE has been created. It tends to be questions to do with attribution of profits and certain instances about the application of withholding tax provisions and how withholding tax provisions are interpreted. So it tends to be the case that these are the typical areas where MAP procedure can be engaged. And the MAP procedure, as I have highlighted, would usually require that first you request through the competent authority, where you request your revenue authority to engage. So typically, and I'll give you a good illustration, this would usually apply, for example, in Kenya's case, one big troublesome issue is whether withholding tax applies in the case of, for example, the Kenya-South Africa DTA or the Kenya-France DTA. A reading of the double tax treaty is that withholding tax should not apply on a payment made by a Kenyan person to a person who is resident in in South Africa or in France, provided that that person in France or in South Africa has not created a PE in Kenya. Now, the Kenya Revenue Authority typically disagrees with that interpretation. So as a consequence, such a matter is one where it would be forwarded to the relevant authority. So Kenya and South Africa would try and sit around a table to agree on how will that provision be interpreted. So usually it would be to invoke the process. It would be a taxpayer who has been taxed by the Kenya Revenue Authority, who would then go to their relevant competent authority to say, please, can you, through the mutual agreement procedure, see whether an outcome can be reached as between yourself and between the South African authorities and the Kenya authorities. So this process will then go through the mutual acceptance procedure to see whether a settlement can be reached. And ultimately, some relief could be given, which is by way of, for example, a credit to the extent that the parties agree. And often, if there is an agreement, the taxpayer will eventually be notified in writing. Typically, I have not seen any success, at least from a Kenya Revenue Authority perspective, of the MAP process being invoked because, as I said, it tends to be voluntary and there is no sort of binding outcome that anyone is forced to engage in. There is also some arguments that could be argued that a tax authority cannot effectively contradict the domestic legislation. So increasingly, we are finding areas where there are challenges in reaching those settlements, and ultimately, as we have said, as I had said earlier, there is no binding outcome that can be given through this mutual agreement procedure. A good instance of such a case was this decision which involved Total Kenya. Originally, they moved to invoke the mutual agreement procedure on the interpretation of withholding tax under the Kenya-France DTA. Having gone through the mutual agreement procedure, there was no decision that was given. And then the matter went to the Tax Appeals Tribunal for hearing. And at the end of the day, the TAT in the first instance held that they did not have the jurisdiction because of the MAP process. And then secondly, and very recently, in fact, the decision was only rendered by the Court of Appeal, by the High Court, maybe a week or two ago. It has now been found effectively that the DTA, the provision on withholding tax, is applicable. So what that shows almost, and this is also a debating point, that the mutual acceptance procedure was not effective. And eventually the parties had to go first to the Tax Appeals Tribunal, and secondly to the High Court in order to reach an outcome through this process. So allow me to stop there. I will share my slides, but allow me to stop there because I think I had about 30 minutes. And I have highlighted the key things to do with both the mutual acceptance procedure and the domestic process that allows for ADR. As I have said, there are certain key advantages of trying to make the process be quick. If you were to allow a matter typically it can last even 10 years from the time that the matter is started till the time that it is concluded, if you were to follow through those steps. But there could be certain benefits of ADR, being, for example, dropping of certain issues through that process, and you only have the issues that remain on the table. Sometimes you're able to actually conclude the dispute fully through ADR. The flip side is that it is non-binding, and therefore it is entirely voluntary on the part of both parties, being both the Revenue Authority and the taxpayer to reach conclusion through ADR. The good thing is that we have seen more and more cases going through that process in Kenya. And that has also been helpful in terms of being able to reach that conclusion. And then I also touched on the mutual acceptance procedure through the DTA. And I think that for all intents and purposes, is a process, at least from my experience in Kenya, that has not reached much benefit, just purely from a perspective of the nature of the disputes that are rendered. Thank you very much, Rachel, and I will now hand back to you.
Very much, Daniel. This was very comprehensive, and I think it even deserved perhaps more time than we had. I think we shall just take a few questions. I've already seen questions coming in on this dispute resolution aspect or arbitration. I think sometimes there's a bit of little faith in it. There's a question from Benon Juko. He says that his question is with the MFP, is that what happens if the injured party says no to arbitration? Will the states leave the matter on the table, or will they continue without the injured party's consent? What happens in that case?
So it's actually a good question because, as I said, the map is between two state parties, and the state parties would, the example I gave of that Total case, the state parties will.
Okay, Daniel, we have you on a hold. Can you hear us? I seem to see you held right there. Okay, can hear you now.
Is it any better now?
Yeah, much better. Still have you frozen, but I can hear your voice, so you can carry on.
Can you hear me?
Yes, can hear you now.
Okay. So what I was saying was that the mutual acceptance procedure, even though it is set out in the double tax treaty as a mechanism of resolving disputes between parties, in reality, it's very difficult to successfully invoke, because if there are many scenarios, so scenario one is where the competent authorities themselves don't agree. The second scenario is where they agree and the party feels that they do not that the outcome is not what they were hoping to get. So a good example is if an adjustment is agreed on and the adjustment is too much or much more than what the party was hoping to get. Because the party still has the recourse of going through the processes in the High Court, they would not be compelled, even though they have taken the two tax authorities through that mutual acceptance procedure. So it tends to be quite a voluntary process, and one that does not compel the parties to even discontinue, for all intents and purposes, any process that was ongoing in the High Court or the Court of Appeal or the Tax Appeals Tribunal for that matter. So it could well be the case that a mutual acceptance procedure comes out. And I mean, an outcome comes from the mutual acceptance procedure, and that outcome is either not acceptable to the parties, in which case they can continue through the litigation process in the courts. And also, just to also point out that unlike the case of ADR, where you can ask for 30 days, 120 days for ADR to be conducted, the process does not stop when you're invoking the mutual acceptance procedure. So it could be the case that by the time even the authorities give you an outcome, already the matter has been decided by the Tax Appeals Tribunal or by the High Court, as the case may be. So it's quite a challenging process. And I would welcome views from Patrick and also Solomon to see whether they have seen any success by invoking this process. But I think typically, because there is little faith in it, most parties just prefer to go through the process of disputing it through the courts and see whether there's an outcome that can be reached. Thank you, Rachel.
Yeah,
thank
Gumi,
you,
sorry,
Daniel. I think
I couldn't
Patrick.
make a comment. Yes.
Yes.
Yes, and thank you, Banangumbi, for that wonderful presentation. I'm very passionate about TDR, you know that. And I have got 2 comments or 3 to make about this area. Number one, I'll make on MAP. I was involved in the MAP negotiations between Kenya and France. That is in the Totaro case, which we did in it was January 2019. And I must admit it's quite a useless process because number one, one state part doesn't have to give a convincing reason why they are holding to their position. Number two, there is no requirement that there should be a report indicating the reasons that that have made them take that position. And therefore, maps normally just collapse without much details. However, before that map took place, the previous 2 years, we had one map with the UK, which was successful. And the reason why it was successful is because when we did our position paper and exchanged with the UK saw the point, and what they did was to give us a counter offer. So they didn't quite agree with the entire adjustment that we were suggesting, but they offered to concede to some amount, which was a little bit less than what we were demanding, and the settlement was done on that basis. Maybe the other point I would like to make around MAP is the fact that normally when you go for MAP, it's presumed that that income has been taxed in one of the country. That is, if it's a Kenyan taxpayer, it's assumed that that income has been taxed in the UK, and that's why the taxpayer is insisting and saying you can't have the income tax in Kenya because of already taxing in the UK. And therefore, should there be a MAP process, and both competent authorities are able to agree on the division of profit, then in most cases, the taxpayer would accept. Why? Because the additional tax that we paid in Kenya will be refunded to the taxpayer by the UK HMRC. And therefore, in a MAP situation, a taxpayer is not supposed to suffer additional tax other than a penalty, if there's a penalty. So it's normally that reconciling. So if they're able to agree at that level, most agree the taxpayer will also agree to that. Maybe the other dimension of it is the fact that even where there is MAP, it doesn't stop the domestic process. You can still go to the tribunal, you can still go to the court. At least for now, that's the legal position. Before that, the tribunal had issued a different directive in one of the cases I was involved, and where they invoked another doctrine of exhaustion of processes, and they actually refused to admit the case before the tribunal. But later on, a contrary decision was issued, and therefore now it is clear that the two processes can go on, concurrently. Then possibly the other point I'd like to make, because I know there are Kenyan lawyers here and the lawyers from East Africa community who would like to practice in Kenya in this area of tax, is the fact that I think going forward, we are going to see very many disputes, and these disputes, most of them will be going to court, because right now, Kenya does not have a law that provides for a waiver of interest and penalty. For the longest, we have had this law, and at some point, it was almost automatic that you get waiver of interest and penalty. But as you know, Kenya is quite cash-strapped, and the last few years, we have seen a lot of resistance by the commissioner to waive interest and penalty. And now that law has been repealed, we don't have that law. And therefore, we expect to see a very big assessments that are going to be enforceable as long as you accept the principal tax. Then the resultant penalties and interest then will be enforceable. And even now, making one matters worse, in this area that Sagumi has just covered, 40p adjustments. Now we also have what we call secondary adjustments, and also a law that was repealed that sort of allow the taxpayer to get a credit. For instance, if you have a Kenyan company with maybe a related party in the UK or elsewhere, and the services have been rendered to the Kenyan company and management fee has been paid or any other kind of fee in relation to a service, and subsequent to that, there is a TP audit, and that payment is reduced by way of an audit adjustment. Then remember, withholding tax has already been paid by the UK company in Kenya. Yet then we are saying that that amount now has been reduced through the audit. So should the UK company be refunded the withholding tax? Now the current law is that they cannot be refunded the tax that had been paid. That tax just goes like that, and that's a legal position now. And number two, whatever adjustment has been made, there is a further secular adjustment. And the argument is that that money has left, the money is not coming back, and that money is now deemed to be a dividend, and there is a withholding tax of 15%. And therefore, if you sum up the taxes that will apply to just a small adjustment, it's possibly more than 50% of the value of the service. And therefore, we are going to see going forward very big assessments that are enforceable unless the current legal position changes. And finally, on the objection out of time, you note that the law in Kenya is such that you must violate the law first and then apply for extension. What I've been doing at Deloitte is that I've been making an application before the due date. And there has been a lot of debate whether that is legal or not legal, because at the point I'm making the application, I have not violated the law. But the argument that I had with the KRA is, why should you wait for me to violate the law and then apply for extension of time? It would be just to be at your mercy. What happens if I apply and you don't allow me? Then what happens? And therefore, what I've done is that the last month I pushed 3 cases and I got an extension of time. I got a further 15 days, 14 days in one case, 30 days in one, and 45 days in another case. So maybe, Banagumi, that is something that can also help some of your clients. I think I could stop there because we may end up, rehearsing what Gumi has said, and he had covered this topic quite comprehensively. Thank you.
Thank you very, very much, Patrick, for that comprehensive addition. I also must say that in Uganda, 30% when you're applying to the Tax Appeals Tribunal to object to the decision of the URA or the Uganda Revenue Authority. In Tanzania, I see Baraka says that a person is required to pay 1/3 of the assessed tax on or before the due date for lodging the objection. Yes, and maybe just 2 more questions for you, Daniel, just before I release you. There is a question again from Baraka. He says, thank you very much for the good presentation. What is your comment on the requirement to deposit a certain amount of money for your matter to be determined? Don't you see that it's against the right to access justice for those who are not able to pay? What's your take on that?
Thank you very much, Rachel and Baraka. Just to say that in Kenya, we have always taken the view that our constitution is actually quite strong on the right to access to justice. In the last 2 finance bills, there has been an attempt to introduce a requirement for a compulsory deposit pending hearing and determination of your matter. In both cases, representations have been made by various members of public, from the lawyers to the accountants to the National Assembly, to the effect that such a provision would be found contrary to the constitutional requirement that says that you have a right to access justice, and that right should not be limited by virtue of the requirement to deposit an amount. Because it is quite possible that once the matter is heard in full, there will be nothing to pay. And had you paid the deposit, either directly to the Revenue Authority or in certain cases to a third party, like a court, it means that effectively you have been denied justice and nobody will pay you any return or interest for the money that you had put in. So what we have done in Kenya is that we have challenged that. We have challenged it every time a provision has come through the finance bill. So far, we have been successful. At least we were successful when it was attempted in the 2023 finance bill and also in the 2024 finance bill. It had also been attempted earlier, much earlier at the time when the Tax Procedures Act was coming into force. And in all this, that was back in 2015. And in all these instances, we were able to push back. But like I said, the challenge that arises is that if you have, and I agree with the comments that had been made by Bwana Patrick Chege, if you had effectively, and this is prior to the Finance Act 2023, because the Finance Act 2023 introduced a provision which effectively said that as long as you have appealed to the High Court, then the Kenya Revenue Authority cannot issue agency notices. But the position as it stood prior to Finance Act 2023 was such that if you're appealing from the Tax Appeals Tribunal to the High Court, unless you have stay pending hearing and determination, the Kenya Revenue Authority was free to begin enforcement of the decision they have received from the TAT. So you would inevitably have to go to court and you would seek stay pending hearing and determination. And most courts in Kenya were not giving stay unconditionally. It was always conditional. So the stay would be conditional on some form of a deposit. So then the debate used to be, what is the form of the deposit you're giving? Is it a bank guarantee? Is it an insurance bond? Do you deposit the money with the High Court? And if most times people would avoid depositing money with the KRA, because once you deposit money with the KRA, it's unlikely you get it back without much trouble in the future. But even then, because it's a negotiated process, it used to be the case that that would be up in the air for a while. Now, the reality in Kenya, because I know there are many Kenyans also on this call, is that the Finance Act 2023 has now been found by the Court of Appeal to be contrary to the Constitution and therefore null and void. And therefore, I believe we will resort back to the position as it stood prior to Finance Act 2023, which is still will need to be negotiated and conditional on being granted the right to, the conditional stay by the High Court or the Court of Appeal, as the case may be. Thank you very much.
Okay, thank you, Daniel, for that. And excited to hear that Kenya has a bit of flexibility, much as Uganda has, even on the payment of 30%. At least the taxpayer is allowed, time to pay perhaps in installments and to make sure that at least by the time the matter is being litigated, you've paid. And then there's also room for mediation at the start. So by the time you're doing the 60 days mediation prior to the hearing, then you can pay the 30% within that period or even beyond that period. So yes, thank you. It's good to know that there's that flexibility with the regulator. So I'll just take you to two more questions. I know our time is fast spent, but I think it's also critical that we address some of the questions that are coming our way so that there is ultimate benefit for our participants today. So there's just two questions on transfer pricing, and I'll start with Wisdom Mukama is asking about, as far as transfer pricing disputes are concerned, what evidence supports the arm's length nature of the transfer pricing arrangement? That's question number one. Just allow me to ask them both so that you can attend to them at once, if that's okay, Daniel. Then the second one would be from Samson Deritu. He also says, under the transfer pricing item of litigation, is the subject pegged to substance or the scale of probability? This might be quite broad. Yes, so Daniel, over to you, just perhaps in a few minutes before we can go to our last question. Thank you.
Thank you. I'll touch on it very quickly because I know also Patrick, who is on the call, is an expert in TP. But typically, the second question first. As far as transfer pricing dispute concerned, what evidence support the arm's length nature of the transfer pricing arrangement? So usually you do what's called a comparable analysis. A comparable analysis should provide a basis for you to determine what would other unconnected independent parties undertaking the same nature of the transaction charge in a similar transaction based on similar assets applied, similar risks undertaken, and also based on the functions that are carried on. Going to the first question by Samson Derito, under transfer pricing, item of litigation is a subject pegged on the substance or the scale of probability. It's quite a broad question, as has been highlighted, but I think usually what happens is that the Revenue Authority will undertake its own assessment on based on three factors. What are the functions that the parties have undertaken? What assets have been applied, and what is the risks that each party has undertaken? And then they conclude that you probably have applied the wrong either formula or method of achieving your transfer pricing policy, or that you have assessed yourself incorrectly based on those three parameters. So typically that's where the disputes arise, but it's quite a broad question. The only thing I'd say to the organizers of this call, perhaps there is a need for a more detailed transfer pricing session, because a lot of the questions that have come today are on that session, are on that question. Thank you very much, Rachel. Over to you.
Yes, thank you, Daniel. And indeed, you're right. When it comes to transfer pricing, I believe it needed probably a bigger session than this. Maybe with the next time we could have it considered and broken down. So I think, Daniel, I'll release you at this point so that we can make some time for Patrick. I see our time is very fast spent. Thank you very much for the session you've just taken us through. It's been very insightful, and the fraternity sends its uploads as well. Thank you. I'll just go back quickly. I don't know if we still have Solomon on call. There's just a question that came right in that I think just after he had dropped off, or after his presentation, that I think he might have to address in a minute so that we can carry on with Mr. Chege's presentation. Solomon, are you still on?
Yes, I am.
Okay, so there's a question for you, which I think has been discussed probably in detail, but you could just quickly say something about it. And this question was from Bernard Milewa. He asked and said that kindly comment on disputes relating to customs disputes in East Africa. So maybe in a general overview.
Can you hear me?
Yes, we can hear you. We can hear you really well.
Okay, yes. So the customs disputes, the East African region uses the East African Community Customs Management Act, but it is interpreted by the local courts, and it is actually possible to have a situation where the different countries can interpret it differently, despite the fact that it is the wording is more or less the same. With customs disputes, they go through the East African Community Customs Management Act provides for an objections process, an internal review process for the objections, and then when that is not successful, it goes to a full hearing. Maybe what I could also comment on that I do find interesting about customs is that they do have an expedited procedure, at least the practice in Uganda. An expedited procedure for dealing with some of the offenses. When offenses are committed, they can be dealt with a lot faster through compounding of offenses, something which in domestic taxes takes a lot longer, whereas for customs it can be done quite rapidly. I think.
Thank you, Solomon, for that, and for the response you've given. Thanks again to you and Daniel. So please allow me just quickly introduce our last panelist for today. And this will be Mr. Chege Patrick. He's going to take us through the need for a harmonized East African community tax policy or policies. the law and its implications on cross-border litigation. So quickly, just allow me indulge you on who Patrick is. He's an associate director at Deloitte East Africa. It's an audit firm. He heads the tax controversy and dispute resolution business unit and supports the transfer pricing and international tax business unit on technical matters. Patrick has been instrumental in resolving a myriad of tax disputes at the Tax Appeals Tribunal and alternative dispute resolutions for taxpayers across various sectors. Prior to joining Deloitte, Patrick worked at the Kenya Revenue Authority, that's the large taxpayers office, for 26 years. At KRA, Patrick worked as a manager in the banking, agriculture, and excise and manufacturing sectors. Patrick also headed the International Tax Office for about 10 years, during which time he was involved in auditing of cross-border transactions. Other functions associated with the office included tax treaty negotiations, mutual agreement procedure, that's a map that you just talked about, participating in base erosion and profit shifting meetings and tax dispute resolution. He participated in capacity building in several African countries on international tax matters, including transfer pricing under the program Tax Inspectors Without Borders, a program initiated by the OECD and supported by the UNDP. Patrick holds a master's degree in law and a bachelor's degree in economics. He's also certified public accountant of Kenya. Please welcome with me Mr. Chege Patrick, that will take us away for the last part of this session. You're welcome, Mr. Chege. Over to you. Can you hear us?
Yes, I can hear you. My screen has been posted by someone. Can it be released kindly? I want to believe it is your office.
Oh no, I think it's I don't know if it's a glitch on your end because our side seems clear of this. We can actually see your screen.
You can see my screen.
Yes,
Okay.
we can see the screen.
Okay, you can see it is okay then. Okay. So thanks a lot. And obviously by coming last, I've been logged off like 20 minutes. And therefore,
Apologize.
yeah, I'll try to rush it through. Yeah, so yeah, our discussion today would be focused on the need for harmonized East Africa community tax policies and law, and how that affects cross-border litigation. Allow me to go straight to the establishment of the EAC. And EAC is basically an edict of the law. It was created, it was founded in 1999. And this is after the collapse of the first EAC, which basically collapsed in 1977, as you can remember, due to some teething disagreements between some members, and specifically Kenya and Tanzania. And therefore, the three countries came again together around 1999 and decided to revive the East African, community. So a treaty was signed in the year 2000, and that's what established this organization. Now, the unique thing about the current EAC is that it has more members. It's not the traditional 3 members. It has 8 members. So we have about 5 new members, being Rwanda, Burundi, Somalia, South Sudan, and the DRC added to the list. And therefore now we expect a bigger market. The EAC has basically 4 pillars. And the first pillar being the custom union. And this one basically focuses on matters of customs, the movement of goods, the market of goods, whereby the states agreed to establish a so-called a free trade, zone where selling of goods amongst the partner states are not going to be subjected to duties. So basically what they have done is to collapse the borders and create one external border and therefore creating what we call an external tariff. So when goods are being sold, like for instance, from Kenya to Uganda or to Tanzania or to any other partner state, there's no duty. But when a third party is selling to any person within the EAC, then there will be a common tariff. And the tariff must be the same. Because you can imagine if Uganda decides that when you're saying to Uganda as a third party, the tariff is 5%, for instance, Tanzania decides 10%, then you're going to, and then within the East Africa, countries, there are no taxes, basically. Then it means third parties would prefer selling through Uganda than Tanzania, and that will now give Uganda an advantage over Tanzania. And therefore, because of that, the tariff must be the same. The second pillar is a common market, and I think this is what we are going to focus on more. And basically, this is common market in relation to goods, in relation to services, movement of people and capital. And there is an instrument that supports this, and this is the protocol on the establishment of East African Community Common Market. So it gives that prescription, and it also adds some two rights, which is the right of establishment and the right of residence. And later on, we are going to see exactly what does this entail, the four rights and the two rights and the four freedoms. Then we have the third one, which is called the East African Monetary Union. This is obviously this idea that in the fullness of time, the East African countries should be able to come up with one currency to be used across the East African community member states. And therefore, what will happen is that it will be sort of like what happened with the European Union, where the Deutschmarks, where the French francs and others were all done away with, and now we have euro. So we shall have a currency which will neither be the Kenya shilling or Tanzania shilling or Uganda shilling or Rwandese dollar. Franc. It's possible to be a currency of with another name. But so the treaty here was signed in 2013, and what was thought is that in 10 years we shall have achieved that, but that hasn't happened, and therefore this is still a work in progress. Then we have political federation. Possibly this is the most ambitious, and is provided for under Article 5.2 of the treaty that created the East African Community. And basically here, this idea that the states wish to come together to form one state or one super state, possibly with one president, and possibly they would decide what the substructure would be, downwards. This is not a single event, it's an ongoing process, and we hope that one day this dream will come true. Yeah, I think it's then also important to look at the administrative organ of East African Community. We have about 7 levels or 7 organs. We have the first one being the summit, and the summit basically consists of membership of the presidents of the respective states. And then we have the Council of Ministers. Basically, this is where the work is. And these are the ministers who are responsible for the EAC affairs. Depending on the country, some are called cabinet secretaries like Kenya. In other countries, they're called ministers. Doesn't matter. As long as you're the person responsible for the EAC affairs, then you become a member there. Then we have the coordinating committee, we have the sectoral committees, we have the East African Court of Justice. Then we have the IARA, the East African Legislative Assembly, and then we have the Secretariat. Now, the focus of today will be the East African Common Market, because this is basically where we are all interested, even as lawyers who wish to, to practice across the East Africa, and they'll be tapping into the big market. If you are a Ugandan lawyer, you'd want to come and litigate in Kenya, in Tanzania, and other places, including South Sudan and DRC. And therefore, that will present a big market for you, and which is a good thing. And therefore, that then comes under the East African Common Market, if it is achieved. And this has been defined at Article 1 of the EAC Treaty to be the partner states' market integrated into a single market in which there is free movement of capital, labor, goods, and services. So it's assumed that there will be no hindrances, there will be no unnecessary either tariffs or non-trade tariffs that can hamper labor. For instance, if you want to go work in Uganda, then you shouldn't be taken through a very rigorous process. It should be as simple as any other Ugandan walking to a company to ask for a job, and it should be, that's how it should be. That is what harmonization is about. And that applies also with the other countries. Again, movement of capital, the same labor, and also services. And then looking at Article 83E, this one puts a responsibility on the partner states to harmonize the tax policies. So partner states are required to harmonize their tax policies so that they can remove distortions. You can imagine, for instance, if in Kenya we have, say, higher taxes than another country, like, say, Rwanda, then someone would prefer to go work in Rwanda, not in Kenya, because in Kenya, then the take home will be less. So all these are supposed to be harmonized. And if you want to understand how bad it can be, you think of any country, like, say, and for argument's sake, let's take Tanzania, with quite a number of provinces, and each province has its own tax laws. Then you can imagine how labor, capital, goods will be moving from one province to the other to take advantage of the difference in tax rates. So when you collapse the markets of East African countries, then that's the kind of a situation that has been created. Now, to remove that, then countries must make effort to remove distortions, to harmonize the laws, possibly not to ensure that the laws are exactly the same, but laws that one can live with and cannot influence certain decision making when you're doing business. So what are the silent provisions of the East African Community Common Market Protocol? Now, we focus at Article 7. Now, Article 7 provides that partner states must commit to guarantee free movement of persons. And this is what we now enable you to go practice maybe even in another state. So partner states are supposed to desist from discriminating citizens from other states in relation to or compared to their citizens from their own state. So they are supposed to facilitate free entry, they stay within that country, and also exit, so that it becomes now a free market. If there are restrictions in terms of entry, or even the stay and exit, then those becomes market distortions, and that then affects how the market operates. It cannot be a market, but it will be something else that is not desirable. Then Article 10 provides for free movement of workers. Again, you want to go work in another country, you should be able to be facilitated. And under that, there's a specific provision that a worker has a right to be accompanied by a child or a spouse. And even the spouse can still, once in that country, look for a job like another person. But there's a caution here, and Article 10 does not apply to employment in public service unless the rules of that country now allows. Then it's also important to note that there is a caveat: the free movement of workers, not absolute. It has to be subjected or caveated to host partner laws and on grounds of public policy, public security, and public health. And that I think this is very important, because then this will affect everyone. Then Article 24, it provides for free movement of capital. Again, any restrictions should be removed in terms of, we want to, for instance, take your capital to another country, maybe in terms of, maybe it is money, cash, to go invest there. Then it should not be subjected to different standards. Like, for example, saying, I want to, lead someone in Uganda, and the withholding tax, for instance, in that country is 10%. I shouldn't be subjected to a different standard. And therefore, the state must remove any discrimination based on nationality or place of residence, or even where the capital is invested. It should be as free as that. Then states should also desist from introducing new restrictions, and so on and so forth. Now, beyond that, we go to Article 16, which also guarantees free movement of service and service suppliers. And this is under the 4 modes of supply: 1, cross-border; 2, consumption abroad; 3, commercial presence; and the presence of national persons. That is, if you have to go there personally. So under all those categories, then person should enjoy a guaranteed free movement. So, and I'm sure this is where most of the lawyers would fall. They would want to let advice for it, maybe from Uganda to another country, like Kenya or Tanzania or South Sudan. And they would want to know how the service will be treated. And we are going to see this towards the end of the presentation. Then Article 17, this one now addresses service partner states in relation to services and service suppliers. And therefore, they should not be treated no less favorable than suppliers of the state. And I think all these provisions are trying to promote fairness and to ensure that every person within the EAC is treated the same in whichever country he goes. Yeah, so that is that. Then in terms of yes, so now so far we are seeing laws that are saying accord people providing service, goods, selling goods, and so on and so forth, the fair treatment, remove this, remove that. And I would call that utopia so far, because a lot of that has not been fulfilled. And therefore, it's important then we look at the scorecard. How has the market, fared? When you look at the appraisals that has been given to EAC by even the ministers, people who interact with the community in terms of engaging them what to do and what not to do, they don't have a very kind verdict for EAC, because the first verdict I came across is that even now we have people selling goods to the East African community enjoying lower tax rates, duty rates, than the EAC members, which is quite ridiculous. So that is the first verdict that I've seen, and you can see this was by Phyllis Wakianga, the CEO of Kenya Manufacturers Association. and saying that the current tariff regime undermines industrialization effort by favoring import or subsidizing importation cost. So this has many applications, including employment and so on, because then it means jobs are being exported elsewhere. Then there's also lack of monitoring framework. And this is, again, by the same person. It's an observation that has been made that the EAC Elimination of Non-Tariff Barriers Act was enacted in 2017 and assented by partner states. And therefore, in 2017, it was in force. But to date, the Secretariat has never developed a monitoring framework for implementation. And therefore, you can see this is a major lapse. And therefore, this is quite an indictment of the EAC, performance of EAC. Then the other observation is that things are not as smooth. As you can see, Rwanda, Burundi, then we have Rwanda, Uganda, then Kenya, Uganda. They're always involved in fight over border trade, which the Secretary has been unable to resolve. So these are signs to show you that things are not as good, and therefore we are not able to achieve the kind of free market that was contemplated. Then the other verdict is that most of the taxes have not been harmonized across the region. And this is basically leading to high cost of doing business. And related to that, you can see when you look at the 2024-25 budget, the bills across East Africa, Kenya, Uganda, Tanzania, and even Rwanda, the verdict is that only corporation tax has been harmonized, at that %. Now, in Kenya, I dare say that personal income tax has not been harmonized, because now instead of harmonizing it, what we have done is even to increase it. We have now a band covering that 2.5% and even that 5%. So you can see they're very, very discrete. So sort of this, we are drifting from the principles of EAC. Then we also note that the EAC has been hit with the liquidity challenge, and therefore with funding problem, they are not able then to run their projects properly. And possibly that's why some of these activities or initiatives have slowed down. So you can see there's quite a number of hullabaloo about funding. There's underfunding when they're expected, for instance, to contribute $8.2 million. They are only able to achieve $7.8 million, and the rest is a deficit. So I don't know how that should be covered. And you can see they're struggling with how do we then achieve the model of financing. Should we have a two-tier kind of, financing? But sadly enough, that has not gained consensus, and therefore this still remains a proposal. And to date, they still carry this challenge of funding. The other thing is we have very, very old treaty rules and procedures that were basically drafted when the members of the EAC were only 3, Kenya, Uganda, and Tanzania. Now we have 8. And the rules have not changed, and therefore there's a problem. You can imagine when countries were only 3, it was important that for quorum all countries are present. Now to date, that is still the situation when there are 8. And therefore, what I've seen being complained of is that if one country is not happy with what is being discussed, they just need to absentee themselves, and then the whole sitting collapses, which is not a good thing. And therefore, I think they should then address the quorum issue. Should the quorum be the 8/8, or should it be at least 6 out of 8, where the other 2 are supposed to be bound? I think that is something that is in the pipeline. I think very, very important for implementation of some of these policies. Yes, so what are the consequences of failure to harmonize tax rules? One is high cost of doing business. because most taxes have not been harmonized across the region. And therefore, there is a high cost of doing business. And then we also have low levels of intra-EAC trade. So it was expected that trade among the East African community members will increase. But what has been observed is that, in fact, there has been a reduction. If you look at a regional bloc like EU, intra-EU trade is 70%. We are at 20%. In fact, some writers put it at 12%. And therefore, it means we are really not doing well. I know there could be many arguments, some of them being that most of these countries are agricultural-based countries, and therefore they may not have business to the level of EU, who are manufacturers. There's also some agriculture in it, and many other kind of businesses. But at least I think we can be doing better than 20%, possibly to move to 40%, 50%. So this low level of trade has been blamed on the civil servants, that they are clinging to sovereignty of their own governments. And I know this is about to happen, but there has to be some way of dealing with it. So what are the reasons for the poor performance? One is lack of political will and intra-community misunderstanding. So under this, what you find is that each state is more keen into advancing their own domestic matters than community matters. And therefore, they end up having some initiatives that only benefit their own countries. And when I look at this, I look at Kenya, where I live, and the kind of taxes they are introducing every year. I doubt whether they are looking to see what they are supposed to do under the EAC treaty, because I think some of these taxes may be counterproductive when you look at the larger objectives of the EAC. Then we also have the path of harmful competition, the concept of harmful or competition, basically, which, as you can see, there has been a lot of misunderstanding. Because tax competition per se is not bad, but what is harmful tax competition is what is bad. Because, for instance, if the corporation tax is at that percent, and now you start competing, lowering tax rate to 25, the other one will go to 20, the other one will go to 15, and then you get to what we call the rest to the bottom. That then becomes, harmful tax competition. But introducing taxes on a number of items, not multiple taxes, but just being genius, looking at your country and seeing where there are leakages and introducing taxes, that is basically not harmful. And therefore, it's important to distinguish between harmful tax practice and tax competition, because some competition is not bad. Then we also have the policy of legal standards on tax competition. Again, here, we are looking at this from an economics perspective and from a legal perspective. And what we are seeing is that most of the standards have been done from an economic perspective. And the economic considerations are quite different from the legal considerations. So while economists would look at the analysis from the rates and the tax-based perspective, lawyers will tend to look at it from the side of freedom of choice and basically the fair sharing of taxing right. And therefore, these two approaches are different, and therefore it means we need to have more studies that are legal-based. Then what about us lawyers? What does this, have for us? We have seen that most of the laws have not been, harmonized. So where do we stand? So if today you are a Tanzanian lawyer going to Uganda to practice, for instance, what kind of environment you're going to meet there? Now, under the current, legal environment, you are likely to face the following. Number one, if you are in Tanzania and you establish a branch or a practice in Uganda, then you are likely to have payments, maybe to and fro, maybe some from Uganda to Tanzania and back, depending on the flow of services. And therefore, when that happens, then you have to observe the principle of arm's length. And under this, it means the pricing of services between the parties basically is what is covered by that. So whenever you have that kind of relationship, then you must know that you must ensure that the pricing is arm's length. What the income that should be reported to Uganda should be commensurate with the activities that are in Uganda and Tanzania likewise. Then there is also a possibility of double taxation through sectoral adjustments. The number one, and I'm happy that sectoral adjustments are not in Tanzania and Uganda; they're in Kenya, and therefore this should be a Kenyan, headache for now. But remember, there is no DTA for East Africa that is operational. And therefore it means even if there's no sectoral adjustment and URA or TRA decides to carry out an audit on you and make an adjustment, and there's a dispute, you can only go to the courts in Uganda or Tanzania because MAP is not available for you. MAP is only available where the double tax agreement. And therefore you can see if rules had been harmonized and there was a MAP, a DTA in force, then you'll be able to also to access MAP. Then the other thing you are likely to face is a complex determination of the PE's income. PE is basically permanent establishment, depending on the business formation that you prefer. The exact possibility, and that's provided for under Article 15 of the draft East Africa Community DTA. So once it comes into force, then this Article 15 would be able to help you. Now, the issue with the PE, termination of income of PE, is that it's quite complex. Even with developed countries, it's quite a complex area, and therefore you are likely to face that. I've talked about MAP, which is all provided for Article 26 of the draft, the DTA for the EAC. And then you're also likely to face a high withholding tax rates on legal services because no harmonization has been made. I know at least for Kenya, there's a special rate for the East African community, services across the region. The withholding tax is 5%. I'm not sure whether we have the same in Uganda and Tanzania. I'll be hearing from experts from those countries. And finally, under income tax, if there is an audit and you are paid withholding tax, the excess withholding tax cannot be refunded because then you will not be able to engage under MAP. So that's important for you. Now, in as far as VAT is concerned, import of service is vatable in the country of consumption. For instance, if you are a Kenyan and you are rendering some maybe consumer service to a client in Uganda, then the country it is the country of consumption, which is Uganda, that is supposed to, VAT is supposed to happen in that country, not the vice versa. And this is common even with the EU. Now, export of service is either related or exempt in the country of source. So if services are emanating from Kenya to another country, then in Kenya, in terms of VAT, there'll be a zero rate. Or worst case scenario, as it was 2 years ago, it was exempt. But the most preferred is zero rate because exempt has an additional cost. Then you're also likely to face a complex principle, which is destination principle. And I think there are quite a number of cases litigated in Kenya in this field of contestation. because sometimes it's hard to tell which is the country of consumption. And therefore, it is possible for any party to argue that the place of source is still the place of consumption as it has happened in the past or the other country. And therefore, that becomes a very complex, principle. And you may also face some complications in the VAT funds. Again, based on the same analogy, whether there was the export of service or not. And obviously this then may also lead to double taxation because Kenya may insist on charging VAT, Uganda also insists on charging VAT, and therefore on the same service, then there could be double taxation. So what's the way forward? And I would rush through very fast here. This is in as far as the lawyers are concerned. And possibly there are a few areas that can be harmonized here for lawyers. One is to develop a law that creates a homogeneous legal basis that could be applied directly in all partner states. Maybe that can help or go a long way into harmonizing. Then reciprocal mutual recognition of practicing certificates, such that if you are qualified in Tanzania, then you should be able to come and practice in Kenya or any other country. And then harmonization of statutory administrative requirement in partner states. So again, if that is harmonized, that can go a long way. Then also harmonizing training and curriculum, just to ensure that we have right training for everyone across the region. And then, of course, also encouraging advocates, lawyers from across East Africa to be conversant with the rules of each partner state. And that will make their work easier when they go to practice in those particular states. And also maybe to amend the national advocacy practice law, regulations, and administrative provisions to allow for cross-border legal practice. Yeah, thank you. That's the end. I welcome any question.
Thank you so much, Patrick. This was quite a session, and I see there are already lots of questions for you. Although I know that time is really, really out of, we're really out of time. I think we've exceeded by 18 minutes, and I'm not sure we'll be able, but I will probably take 2 or 3 questions, and then we'll probably find a way to respond to the rest, perhaps in the chat or something like that. So there's a question from Priscilla Githinji, where she says, kindly clarify on the lobby process for customs duties that gazette through the ESC Gazette. For example, if a Kenyan taxpayer wants certain duties reduced, how do they go about the process from inception to having the duties approved and gazetted through the ESC Gazette notice? And then 2, perhaps which will be the last one for you, is why has Kenya continuously refused to adopt transaction value model for customs valuation of motor vehicles, yet we have common customs laws. Even for Uganda, it actually happens. So I don't know if it's an East African thing, perhaps it could be the same thing in Tanzania. So if you could just take those 2 and see how to close this. Thank you.
Yeah, thank you, Chair. Let me defer the first one because that one requires a bit of, and I'm sure we'll be able to wire so that we can able to share with her the whole process. So that I think we can chat after this. Let me take the second one. Under the ECMA, sorry, we still have the 6. I think there are 6 valuation methods. And transaction value is the most straightforward. However, increasingly you find revenue authorities refusing to go for the transaction value because they have the impression that goods have been undervalued. And therefore they try to invoke other methods that will give rise to higher custom value. And I would say that they don't accept transaction value because if you're able to defer to a section of value basically properly, then you carry the day. I have debated in several cases and we have won on transaction value, but you really have to debate it properly. And the reason why, sorry, it was easier for me to win those particular cases is because they try to invoke a transfer price and which they were not conversant with properly. And therefore, at least we're able to educate them a bit on how even transfer pricing operates and how the price that was applied was arm's length. So it was easy. So the 6 methods are still available, and the commissioner can dispute any, but you can defend the one that you think is applies to you.
Okay, thank you so much, Patrick, for that. Maybe just one last one that I think that we should also probably capitalize on a bit, and maybe also to give a chance to the anonymous attendee that asked a couple of questions, but I'll just pick one from his or her questions. So he says, kindly expound more on the current tax litigation regime in relation to the current tripartite free trade agreement between the EAC, the SADC, and the COMESA as a single commercial bloc. If you could do that briefly.
Well, I think the cases that I've handled, custom cases, they are all on valuation. I haven't seen a case where the dispute is about whether there was duty or no duty. The disputes are about, is this the right value or not? So where there's exemption, I think there has been no too much of contestation. If a trading bloc exempts or is exempted from certain duties, that hasn't been hasn't been a major area of litigation. I don't know whether Daniel Gumi, who drives in litigation, possibly could have come across some other additional cases, but most of the cases that I've seen basically are on valuation, not whether tax was applicable or not in terms of trading bloc.
No, Patrick, I agree with you. I agree with you that they're mostly on valuation and the methods applied on valuation, and not so much on this issue. I think the question from that gentleman is the coming friction, because in the case of Kenya, we're already signing some trade agreements with the European Union. We've signed with the UK. We are still members of the EAC, but I'm not yet aware of any case that has gone to court on that either.
Okay, thank you very much, Daniel. Thank you, Mr. Chege, and thank you very much, Solomon, as well. I know that we're already 24 minutes past that time. I really usually like to keep us within time, but this session was quite broad, and maybe for the next time, we'll probably break it down or have a topical discussions, because we know that everything that we discussed today is important, and tax is really a breath of life for us. So without taking more of your time, thank you very much for attending this session with us today. We'll definitely have the slides shared so that we can catch up or refer to them or reference them whenever we have to. And for any other questions that we may not have answered, this was not our intention. We hope to answer all your questions, and we appreciate you for being interactive and staying with us till the end. However, we'll take the questions offline at this point, and I'll probably have our speakers perhaps revert in a different platforms or clusters that we belong to, so that we feel we get their responses, and so that we continue to interact. So allow me, appreciate you. Thank you very much for this session. Thank you very much for making the time this afternoon. And I'll hand over this session now to the Secretariat. Gabriel, I see you. Over to you to probably close this up. Thank you very much.
Thank you so much, Rachel. Very special thanks to you for putting this up and for the very stellar conversations that have just taken place this afternoon. We are very grateful to you, our esteemed panelists, Mr. Patrick Chege, Associate Director, Deloitte and Touch East Africa, Mr. Daniel Ngumi, Managing Partner, ALN Kenya, and Mr. Solomon Rukundo, our tax specialist from the Ministry of Finance in Uganda. Thank you. It's been an amazing conversation. It's been quite insightful. And I've been discussing on the sidelines with Rachel on how to have more of such sessions and this time perhaps going in depth. For those who joined us for the session today, thank you so much. We are very appreciative of your support always, every week. We look forward to hosting you. And this week on Thursday, we'll be discussing a very interesting topic on sports washing. And we're wondering, is this the new money laundering or is it a tax sanction avoidance mechanism? So you watch out for that conversation. It's related to tax, and if you're an enthusiast in this area, you would want to stick around and understand what sports washing is. We have an esteemed panel that comprises of very reputable persons from across the region. And yeah, so this recording will be shared with you, like Rachel has said. And you'll also receive a certificate of attendance following this session. So please check your inbox or your spam folder. Sometimes it goes into the spam. But we look forward to hosting you on Thursday. And for those who have joined, if you have not yet had, we are having the in-house council convention on the 5th and 6th of September at Watamu, Kenya. It's going to be the biggest gathering of in-house council in East and Central Africa, and we look forward to hosting you at the session. And we'll also have another convention on construction law in Kigali, Rwanda. So you want to check our website to get more information about those trainings. If you'd like to join our committees and volunteer yourself to speak or to be part of our committees, please reach out to us. Write to us at info@elosociety.org or check our website. So that's from us to you. Have a very lovely Tuesday afternoon and see you all on Thursday. Goodbye.
All right, thank you. Bye, Gabrielle. Thank you. Good evening.